this mother has another child, and that is the last time that this court has had the mother appear before her and with the question of whether or not she's a suitable parent. Back in November, for her other child, Leilani. So this court heard the matter, and all the parties here, with the exception of Ms. Carter, there was a different attorney ad litem, they agreed that that child should stay at home. So the question of her being a suitable mother was most recently answered in November. And it was answered in her favor in the sense that the child was allowed to stay at home. So to question her as a suitable mother.
Right, but the question is this: having made a jury demand, that, and this is a position we've taken for decades, which is the correct one. And that is, if you make a jury demand, the law is that all other parties get to rely on that jury demand, and you can't just waive it. All the parties have to agree, and the court has to make a finding that that waiver is in the best interest of the child. Having made a jury demand saying you wanted the court not to decide the matter, you wanted a jury to decide it, then all other parties get to rely on it. And it would be all well and good if everybody agreed. But if there are parties that don't agree and want to still rely on that jury demand, it would seem intellectually inconsistent to take that away and not allow any other party who has the right to rely on that, their opportunity to present their matter to the jury, which you originally asked for. That's the position we've always taken. That is sort of a pitfall in making a jury demand. That's why it should be done with careful consideration, not because you don't have the right, but because it also makes other dominoes fall. My understanding is that the department wants to rely on that right to a jury trial, is not in agreement with that return, and while the court would have the power to do it, it doesn't seem intellectually consistent to do it and deny the department who filed the case in the first place the right to go forward on a jury. Now, if there was, of course, if this were a summary judgment, that's a different factor. And while the court has the authority to do it, it doesn't seem to be the wise use of it when there are parties with disagreement who should be entitled to their day in court.
Your Honor, if I may, I apologize. I listen. I hear everything you're saying, and I very much understand. I think we're talking about three different things, not just two different things.
Okay.
The last time that this court took up the matter of the suitability of this mother for this child was back in March of 2020. So it's been over a year. I understand what you're saying as to the jury demand and the pros and cons of that and the pitfalls. And I need to talk to my client about whether or not we whether or not we withdraw the jury demand and
you're not just entitled to withdraw it.
I know I have to reach out to the other parties and get an agreement.
But all other parties have to waive it as well.
Understand.
In those circumstances, since I would be the one to make the ultimate decision, I also don't have an intellectual disagreement with deciding that on a motion for a return and monitor, because I would be hearing the same thing, right? And so, certainly if everybody agrees, that goes a long way. But when parties don't agree and people are all in court wanting their day in court, and if jury has been invoked, it doesn't seem intellectually consistent to say that no matter what, look, I get it. You say you have evidence that would win the day. They may tell me they have evidence that would win the day. So who hears that? Right now, it's a jury.
Right. I'm trying to fine tune the argument to just the question of striking the intervention.
Okay.
And by that, I'm citing not this case, not what's happened in this case, but what has happened in the companion case. Another child, and present circumstances matter in terms of the burden and their right to intervene. because they have to allege that the child would be physically or impair the physical harm or the emotional development. But if we have a more recent situation where this court, not in this case, but this court determined for this mother and these parties by agreement, again, with the exception of Ms. Carter, there was a different ad litem, said it's okay for a child to stay with this mother. So that was all I'm trying to say as far as today. But I very much appreciate what you're saying, because you've given us something to digest, and I need to talk to my client about, because I know you're right.
You filed those at the same time, or were they in the same document?
They were in the same document. They were in the same document. So I see why that. Okay, I see where you're going with that, Your Honor.
Okay.
And
I'm not trying to make it overly complicated. I'm trying to make it duly simple, that it's not my role necessarily to deny anybody their day in court when there's a disagreement. And then what form does that take? And right now, it has to take the form of a jury trial, because that's what's on the table. With regard to that, then the consideration is, well, I mean, obviously interveners can't come in until after 12 months. So there are other factors to consider. And on a motion for leave, those cases are more intricate and involve testimony on their motion to leave for leave. Some of the factors are the same, it being discretionary, but this is the tough dilemma in a case where there is an intervener, is what do they bring to the table that's different from what CPS? Are they different from CPS? Do they want the same thing as CPS? If they want the same thing, it's duplicative, and that may not add anything, in which case you could use your discretion to strike it. On the other hand, if they are different, does that unduly complicate the case by adding another party who has a different position than CPS? So you could use it to strike them then. So that's the purpose of this hearing, is to find out, is there something different they bring to the table, which needs to be heard, but doesn't, one, overly complicate the situation, and also doesn't become duplicative. And some parties have intervened just because they wanted to make sure they got all of the pleadings, but didn't want to add anything else. That one was granted. So I'm asking you, tell me, and I've read your pleading. So is there anything else in there that you would want me to consider, in light of the fact that they haven't filed a motion for leave, that you want me to consider on the motion to strike?
You basically said it. I mean, the burden is on them, and it requires them to produce the evidence. The case law is pretty clear on that, and especially in the cases cited by Mr. Nisenblatt.
Motion for leave, so I'm not sure it's the same consideration, although they overlap for sure. Mr. Nisenblatt?
Sorry.
Yes, Your Honor. Because of that overlap is how the department and why the department filed the response it did in this case, and apologize for any confusion that might have caused. Regarding the department's position, the department would waive the jury. We actually would like to move forward to a final hearing, either because of the jury demand made by Mr. Eckel for his client, or if we can achieve a waiver. We've already mediated this case. Our hope is, coming out of today, that there will be a quick trial setting soon, either on the jury docket, now that the juries are occurring due to COVID, the lifting of the restrictions, I believe, at the end of May or June 1st. But if there's a waiver, we'd prefer to try this case as soon as possible. This case is older. I think we do need to settle on the permanency for this child and the child's best interest. Regarding the interveners, I believe the department's plan right now is to seek termination. I believe that would be in line with the request of the potential interveners. We believe it would be duplicative to add them as parties. We'd understand that for the fairness of the process, it would only delay permanency. I believe the case law is pretty clear that prompt permanency for a child is in the child's best interest. And this would kind of go against that in weighing the benefits and costs. There is really no additional benefit, especially in light of the best interest of the child, in our opinion, to continue this case. And whether we go in front of this court for a bench trial or a jury trial, the department would like to request a setting of some kind today, so that we all have a target to get to for this child, for the benefit of this child.
May I respond, Your Honor?
No, let me ask a question first.
Sure.
What if you change your mind? What if the department changes your mind? Let's say I strike Mr. Van Gilder's intervention, but the department changes your mind. Either then if they wanted to go forward with termination, but you're right. If they march in lockstep with you all the way, then it hardly matters if I struck their intervention. But if you change your mind, then it matters. Is there any chance you change your mind?
Well, Your Honor, I don't know if we want to deal with hypotheticals, because we could do that back and forth. I think as we stand today, we're in lockstep with them, with what we want, what the permanency plan is right now. And that's another reason why I think it's imperative that we get a quick trial setting. The longer this lingers, the longer it goes on. There's new facts. We are bound by services, and if we turn this into a sprint rather than the marathon kind of idea, that is problematic. Obviously, to answer the question, if we do change positions for whatever reason, I think they would be entitled to, under the law, to try to intervene at that time. They can seek leave at that time. But where we stand today, and as the facts are today, and where the parties are aligned today, I believe that there's really no need or justification for adding an additional party and further delaying permanency for this child.
Mr. Van Gilder?
Thank you, Your Honor. The Family Code, Your Honor, allows us to either intervene in a case or set a completely separate lawsuit. If the court strikes our petition today, our intervention today, we will file a petition this afternoon. It's already done. Under judicial economy, you're going to then have two cases. So we believe that all the facts are going to be aligned with the same situation. So you would have one case going, and that's everything that would be involved with this, and put it on the table. However, if we have to file a separate petition, then you're going to listen to the same facts over and over again. And so we believe that even though an intervention leave wasn't filed, I believe the court has discretion to be able to grant that under these circumstances. So we're asking that the intervention be.
So let me ask you a question.
Sure.
It's hard to think that you could file a separate case, one, and get to trial before this one, or two, not have it consolidated into this one after it is filed, and then you're right back in the same situation. It would be a virtual certainty that it would get consolidated.
That's exactly right.
So it really is, that's not much of a concern, because if you have the same parties and the same issues filed separately, there's just almost no way that you would either, one, not just have to wait until this one's done. And if you attempted to move faster than this one, it would be just a virtual certainty it would be consolidated. But I'd really rather focus on, rather than that, what do you add to this case? Because we've also interpreted it that CPS having filed.
I'm sorry, CPS having what?
I'm sorry, let me step up closer to it. CPS
Sorry.
having already filed.
Right.
And then let's say it's a grandparent or someone else who, like your clients, wouldn't have necessarily known them, but or had the opportunity, but now based on being in 12 months, has the opportunity, has some standing to intervene, still can't come in and run the show. It's still CPS is the original petitioner and really gets to go forward on their relief first. So therefore, the question in a lot of these considerations is, one, it's sort of a minefield when you intervene to, are you adding something without being overly complicated? That's when those stay in. And when you don't add something, well, why do you stay in? And if you do add something, there's even the possibility that if I think that you should be waiting in the wings, that I not strike it and then abate your action.
We understand that.
Until we've ruled on CPSs. And then but with the condition that the abatement's lifted if they change their stated goal.
You know, Your Honor, we would accept that, I think. But I believe we actually can add to this in terms of, I believe in terms of what the ad litem believes, at least what I've been told from Amanda Carter, but, and basically from what I've just heard from Oscar, I believe that we are in alignment with those people in terms of what the final outcome should be in this case. So I believe we can add something because of the fact that this child has been with my clients for over a year now. This is actually somewhat of a special needs child, which we don't believe that the bio mom can handle, what with having a smaller child and everything else. I mean, she has this young lady is going through therapy several times a week. She does a lot of other things. She has some serious issues that are being addressed by my clients. And I think that needs to be in front of the court.
What if, I really, in analyzing this over the last few days, my question, and I actually thought it might become moot because my understanding is the department wanted a jury trial, but it might focus on that CPS would like to waive jury. And then if you're in the case and everybody else wants to waive jury, if you're in the case, would you think that y'all would want to waive jury or not waive jury?
I obviously haven't talked to my clients about that, Your Honor. I believe there's some very good consideration about waiving jury in this matter, to have it before the bench.
And by saying that, I am not encouraging anybody to waive it.
I understand
and I'm not encouraging anybody not to waive it. It's just a consideration about what you add or don't add to the case.
Right. Well, one of the things, Your Honor, is that obviously I believe we can get in close. Everyone can get in quicker with a bench trial as opposed to a jury trial under the COVID situations, even though things are getting better for you and your court. I would not want to see a Zoom jury trial.
We would not have a Zoom jury trial.
Okay.
100% certainty.
Good.
I would never find that that's in the best interest of the child.
Right. Good.
My concern is then, if we're doing a jury trial in the meantime, even if authorized, how do we separate the jury? How do we have a good representative group come in when we're allowing so many people to, if someone says they don't feel comfortable coming in, are we getting a representative jury? That's a concern.
I agree.
And it's obviously more complicated than those things, but those are my biggest concerns.
Mm-hmm.
So, Mr. Nisenblatt?
Yes, Your Honor.
Would you like to address anything further on the motion to strike?
Oh, no, we'll rely on the cases cited in our response, I think. I'm still a little confused. If there is no motion for leave, I don't know if the backdoor plan that Mr. Van Gilder put forth to file their own independent lawsuit and then move to consolidate. I mean, obviously that would gut what the legislature thought would be the way to intervene in a department case. I think this court correctly noted that it is a department case. And the reason they have those limitations is because when the government has to step in because no one else did, they kind of wait in the wings.
Possibility that whatever I rule on this, would be collateral estoppel on that. But I'm not making any of those arguments for anybody. This is all speculation at this point.
Yeah, correct, Your Honor. And as far as my argument, as far as just wanting a final hearing, I hope it's been clear that the department's just dealing with the demand made by the mother. If it has to be a jury, it'll be a jury, but we're not interested in a jury. We would like permanency for the child. The case is over the time limit, also because of COVID. And we think that this child, a final hearing sooner than later is in this child's best interest. And that's where we'd like to go. And we'd be interested in waiving the jury to achieve that.
Ms. Carter?
Thank you, Your Honor. As far as my position is, I am just fine moving forward with the bench trial. I think a jury trial in light of COVID and everything going on is just going to delay this child's permanency. And, I do believe that Mr. Anderson and Ms. Munoz have things to add because of this child's special needs. I think they've lived it over the last year, and I think they will have things to add at any bench trial. So
We can always, the court always wants to hear from placement. And placement who wants to be heard from, but that doesn't necessarily, if they're not parties, allows them to advocate for termination. That's a different question for them to report about how things are going, even some of their opinions about what they would want to do in the event that the court went a different direction, either by termination or by not termination. But that's different. That's different from advocating as a party. So ultimately, do you think it adds or detracts from this case to allow them to be a party and advocate for one position over another?
Your Honor, I'm gonna have to defer to Mr. Van Gilder as their attorney on that front. It's my position. I plan on calling them as a witness. I think they will have a lot to say at any final trial.
Okay. Casa, let me ask you your position, but I want to be clear. I'm not asking you to give a report about the placement, but just what is, if you were making a statement today about what you believe to be the best interest of the child, would it be termination, not termination? If not termination, what would be the issue about return? There's been a motion for a return and monitor. If a jury is waived, then the court would take up whether it's a final hearing, but that in a sense is a mini final hearing if you don't have an agreement. So what is the CASA's goal at this point?
Well, CASA's in agreement with Ms. Carter that we need to get this settled, that the child is bonded. It's been over a year. She has special needs that have been very adequately taken care of by the placement. And we believe termination would be the best in this particular situation. And that is CASA basically what we feel.
Mr. Eckel, you filed the motion to strike. There wasn't a motion for leave, so you're having filed it. What else in reply that you would like me to consider?
Again, it's what I expressed in the lack of leave. The burden's on them to produce the evidence for this kind of hearing to intervene. The most recent hearing has been that the parent was suitable for a child to stay at home. But I just a quick expression of gratitude. This is an adversary process. This must be alien to Ms. Anderson and Mr. Munoz. And so in front of everybody, yes, it's adversary, but also need to say thank you because yes, you have been taking care of Christella's child. So I don't want that to be lost. I don't, so. That's it, Your Honor. Thank you.
You know, I don't mean to be hung up on anything in specific, but this issue of the jury trial makes me hang up some, because what if the department wanted to waive jury, but Mr. Van Gilder's clients would not want to? And then do we consider them not marketing in lockstep there? I don't really know. Right now, all we have is a jury trial, and too much more than that is speculation. I'm not trying to encourage. I would also have to make a finding that waiving the jury is in the best interest of the child. But of course, if everybody's in agreement and CASA, who's the guardian ad litem, says that's, you know, it's hard to overcome, it doesn't mean that I couldn't. But I believe that the right thing to do is to not strike the intervention and abate Mr. Van Gilder's pleading, and abate it with regard to theirs until such time that it is demonstrated to the court that they're taking a different, unique position from the department. At such time, then they will have been around the case and could pick up the mantle if for instance, though, at that point, if you have all the parties and you make a motion for return and monitor, if I agreed, it may be that just their coming in wouldn't change that. But that's a different matter, and that's partly why that is abated. And of course, if everybody is in agreement and we do waive jury, that's a different question. But your question for return and monitor is, you know, it becomes a mini final hearing in a way. So it also may be that we would just have the final hearing and let everybody present their side, and then there's either termination or not termination. If there's not termination, then there's a consideration of return and monitor. That would be the way it would go without Mr. Van Gilder's client. So, yes, sir.
I'm sorry, I didn't mean to interrupt, Judge.
No.
If my clients do agree to waive the jury, would you then not abate my case?
I'm not sure, because then at that point, if everybody's waiving jury, I still don't know what you add.
You don't know what my clients are asking?
What's that?
You're not sure what my clients are asking?
No, I'm not sure that if everybody waives jury, what unique position your clients add that the department doesn't already represent. And what complicates that is, well, let's say you didn't waive jury. We'd have to parcel out, if you and the department, let's say I didn't strike your pleading, your intervention, and I didn't abate it, and you're a full party and we haven't waived jury. Well, now you've got the same exact position as the state, but now what you get to, do I limit your direct and cross-examination? Do we give you the same number of strikes? And there's all kinds of things. If you're taking the exact same position, I don't have to give you the full amount of strikes.
I understand that.
There may be other complicating factors, but just allowing another lawyer to ask the same questions with the same position that the department does may not add anything. If you're not going to add something and it's just duplicative, that's one of the grounds for striking the intervention.
Your Honor,
Especially in light of Ms.
this is
Carter.
Oscar Nissenblatt from the
Call them as
department.
witnesses. Yes, sir. Mr. Nissenblatt.
Oh, sorry, Your Honor. I think it was glitching a little bit. If I interrupted, I apologize. Just so I'm clear, although there's no motion for leave filed by Mr. Van Gilder, they are being named parties to the action, but abating as opposed to denying without prejudice. I guess I'm just curious as to who would need to agree to the waiver of a jury if they're not
Okay.
stricken, but
Mr. Van
abated.
Gilder, does that, well, Mr. Van Gilder, let me find out, what position do you think that your clients, if their action is abated, would have the right to waive the jury or not? I initially thought that they wouldn't, but I would like to hear what people think about that.
I think they probably would have the right one way or the other to waive it or not. And I've actually been trying to contact them on email while we're sitting here. And I haven't gotten an answer back yet completely because they haven't been able to understand for some reason. They can't hear you. But I think, I mean, I would recommend that they not have a jury and agree with everyone to waive the jury. If that keeps them in the case, and I understand that in terms of an alignment for if there was a jury, we would have potentially fewer strikes would be aligned with the other parties. But I think overall, in regard to judicial economy and everything else, with all the people with the same facts and everything else, I believe that my clients could add something in terms of what the final outcome of the case would be. So I believe they do have a lot to say. They have been with that child for a year now.
Right, but you're pleading and noting that there was no motion for leave there. You're pleading, when I read it, didn't add anything different from the state. And what I heard today, and that's why I was really asking in a very specific, concrete way, because if you aren't adding something different, even if it's nuanced, it would not seem necessary.
May I make a comment?
Mm-hmm.
I just heard back from my client on the email. They will agree to waive jury.
All right, well, I'm going to let everybody kind of huddle up with their own clients and make that decision, because that really, no one had noticed that we were going to take up whether you waive or don't waive jury today, but it can be. I do think that, and part of me thinks that this would be a good trial to have in front of a jury. There are some different considerations I'd like to hear from the community about. But does that mean that I would say that a waiving jury is not in the best interest of the child? I don't know that I would say that, but I do think it would be an interesting jury trial because of the differences and some of the things that Mr. Eckel brought up this morning and was raised in his motion for return and monitor. Though that's a little different from our typical case. So, however, if it needs to be me to decide it, then it would. All I'm saying is this: the pleadings didn't necessarily justify that there is a difference that there would be anything in addition or separate from the state in what you're adding. My idea about not striking it, but abating it is that, one, it should be the state driving this bus. They're the ones who filed, and that there's case law that would support that CPS really gets to go forward first.
Oh, I agree.
They're having represented all of your viewpoints. When I can sit back and say, well, there's nothing really added, especially in light of the fact that they'll probably be called as witnesses. It doesn't add anything. In the event that there was something but I wanted you to be receiving the pleadings, receiving notices, know where that's going, and that would allow that. That's what, if I thought that it meant that I would hear separately from you that you would insist on a jury when everybody waived it, and I was willing to make the finding that that was in the best interest of the child, but you could argue something different, I would probably say, well, we'd strike it. So, Mr. Nisenblatt, I understand that there's in my mind, that's a distinction without a difference, unless it gives them some extra power. I just really wanted Mr. Van Gilder's clients to have anytime something's filed with the court, they get it. But I don't think that either way, they would get to go drive the bus.
Oh, I agree with you, Judge. I don't think, I think obviously the department they're the drivers, without a question. But I think that I still believe that my clients add something, even if they don't.
And I believe that that at the late moment, if the department goes, we want to change our mind, that you're having raised this and now you have a different position, that we wouldn't necessarily under the specific facts of this case. And I don't want to say that this is a blanket rule, so please don't say that, but under what has been alleged, what has been defended with in this specific case, that in the event the department were not going to seek termination, they changed their mind, but maybe there's some new fact that I'm not aware of, but that voice can be heard. But the department adds it. I've heard from the attorney ad litem. The attorney ad litem says it. And so I'm confident that that position is represented. There isn't some nuanced addition that the interveners add, but should they get the pleadings? Should you include them in the correspondences? I believe that. That's what I wanted to accomplish by not striking, but abating. But it really doesn't, if you're all agreeing on the record to send them all of the pleadings as a Rule 11 agreement and all the notices and correspondences, then it also doesn't matter if I strike their intervention without prejudice. I didn't want them to be in a position where there's pleadings, there's correspondences, and they don't know that now they don't march in lockstep.
Your Honor, I still go back. I'm sorry. I still go back to judicial economy, Your Honor. Whether you abate it or strike it and we file a new petition, Family Code allows us to do that. You're going to hear the same. You would end up hearing the same facts in a separate trial, and we believe that this could be just a continuation of that initial trial. And obviously, if the court rules that there should be a reunification with the mother and the child, then it kind of makes my client's request for termination to be somewhat moot. So I think.
No, it would be completely collateral estoppel. But I don't think there's much chance that you then don't get added back into this case and the motion to strike. Well, I mean, in that regard, I'd like to see how that would play out. And so maybe that's more reason for me to strike it, see if you file it, and then and see what would be the legal effect of having been struck here, whether that's collateral estoppel when there's a motion to consolidate, which the court could do on its own motion to consolidate.
It just seems a lot simpler just to put it all in one basket, Your Honor.
I understand, but there is some consideration that you really need to be raising a different issue than anyone else already in the case.
Mm-hmm.
And it seems to me from what has been raised, the only thing is it could come down to whether you have the right to object to a jury trial or that's the consideration. In motions to strike, motions to leave is, am I going to be hearing from you? Is the jury going to be hearing the same thing? Or do you come in adding something different? Do you completely drive the bus and change the case? Well, in some sense, CPS filed first. They drive the bus on pushing the litigation. And so far, I just don't know that it makes any difference what I decide today. Because I don't know that anybody adds something, that it adds something different. Especially in light of the fact that there's a stated intention to call them as witnesses.
Well, obviously, if they're called as witness, I would be able to be there representing them at that point in time.
But not necessarily to question them.
Oh, I understand that. I understand that, Judge. I understand. I just, Judge, I think it's the fairest thing to have my clients still stay in the case like this, as opposed to filing a new case and having it consolidated.
Are the parties agreeing on the record to include Mr. Van Gilder with copies of all correspondence and pleadings filed?
I'm happy to do that.
Oscar Nissenblatt, attorney for the department. I have no problem. We might have to redact a couple things, but everything else would be shared with Mr. Van Gilder under an agreement.
So the answer is yes, unless
Yes.
but you have reserved the right to redact any privileged information.
Yes, Your Honor, and I think it would just be kind of what we'd have to redact anyway under the statutes.
Okay. Mr. Eckel,
That sounds like a good idea.
Ms. Carter?
I have no issue with placement and their lawyer having access to all the pleadings.
Not just access, but if you send something to Mr. Nissenblatt, you're going to copy Mr. Van Gilder. If you file a pleading, you're going to copy Mr. Van Gilder. If you're going to treat him like he's entitled to all the correspondence, it's the same way by Rule 11 agreement. That's what I'm.
I have no problem with e-serving Mr. Van Gilder and CCing him on any email I email the department or Mr. Eckel.
Okay, so I don't mean to quibble, but I'm asking for a positive yes rather than I don't have a problem with.
Yeah.
You have a positive yes from me. I'm sorry.
Okay, Ms. Carter,
I'm sorry, Renee.
Yes.
Mr. Nissenblatt.
Yes.
Okay, so therefore I'm going to strike the intervention and approve that Rule 11 agreement without prejudice to Mr. Van Gilder's reasserting it either by leave to intervene or just renewing, filing a new motion. My concern was that if they don't march in lockstep, then Mr. Van Gilder might not know it. And his clients may not know it. And then therefore, at that point, they wouldn't know to have come in and may do it too late or at the last moment when nobody's catches people unaware, they're caught unaware. With that, with his being able to know based on all the correspondence and all of the pleadings that they could come into the case. And if that is something he can tell the court that there's a basis for seeking some other relief, then we could go forward. Okay.
But there's still potential of intervening in this case since it's without prejudice. Okay, instead of filing a new.
But that's what I'm looking for is what do you add that's different? It doesn't overly complicate the case, but it's a legitimate viewpoint that needs to be heard by the court.
Okay.
And right now, I believe that the department and the attorney ad litem represent that viewpoint already. Okay. All right. So we have a Rule 11 agreement, and then the motion to strike, therefore, without prejudice is granted. And Mr. Eckel, will you draft that, please?
Yes, Your Honor. Thank you.